Thanks very much. So I do have moderator's privilege to ask a few questions, but I don't think we have as much time for questions as we were hoping. So I'm going to take very little time and then turn the floor over to you. So please, if you do have a question, as I said earlier, if you would just line up at the microphone here, I'll recognize you and you can present your question either to one or several of the panelists. Oh, thanks. Just in case you couldn't hear me. I'm not going to try to summarize the panel, and I think we've really had a thorough and rich overview of the various dilemmas and practical impacts that potentially stem from the decision a year ago, and more broadly, and I really want to highlight this, as Joel pointed out, other regulations, restrictions, and administrative guidelines that are affecting organizations, both U.S. and in the U.S. and abroad. So I did want to ask the question, and before we move to those that may have comments or questions from the audience, to the panelists, is there an element to the argument on the other side that you see as reasonable or as grounded in an understanding of security threats that are faced by the United States and other countries here and abroad, that you think the sectors that you work with, so either those working on free speech in the U.S. or those working on peace building and diplomacy abroad or those working in humanitarian affairs, need to respond to? Is there under this a reasonable concern to which your own community could or should respond differently? Or is it your sense that the only possible response to this really is a position that says we already have in place adequate protections against the threat of terrorists or insurgents or rebel groups, and we don't need to go any further in regulating our own sectors and activities? Emily, if I could go first to you, and then I'll just go through the panel in order.
Sure. I think that historically, it's always been a bit difficult to draw the line between something that is regulating speech as speech and something that's regulating activities that might include speech. But I do think that the Supreme Court has made these distinctions in the past, like the case with the communist membership that I mentioned. I think if the material support law were amended to provide that the defendant had to have the specific intent of furthering unlawful activities or violent activities of the organization that it's in contact with, I think that would be sufficient. I think the type of speech that is prohibited by this statute is really what has always been considered core political speech, voicing political positions, voicing dissent, criticizing government policy, and even the government itself has said that this statute would apply if, for example, an attorney submitted an amicus brief in the Supreme Court on behalf of one of these organizations. So I think that it's the breadth. Certainly there is some activity that should be prohibited, but I think it's relatively easy to make changes around the edges that would continue our tradition of protecting political speech.
Yeah, very briefly, again, it's a question of nuance. I've spent years living in 2 different war zones at this point. I'd be the first one to agree with the idea that the United States has enormous national security interests in fighting terrorism, acts of terrorism, violence. But it might be helpful to think of a distinction between terrorism, the action, and terrorist groups writ large. And when it comes to those groups, further refine it. I'm just looking at the FTO list from November 2010. There are 47 groups on the list. Some of these organizations, as far as I know, are tiny at this point. I mean, they may barely exist as a fighting force and have very little political support. Others are enormous important, powerful, democratic political actors in the countries where they're based. So distinctions need to be made regarding the type of group, regarding the scope of their activities, with a focus to sanctioning violence, sanctioning procurement of weapons, all of that, but not automatically closing the door to contact, to having a conversation, particularly if it's in the interest of furthering human rights, conflict resolution, access for humanitarian providers.
Yeah, in our world, it's actually pretty easy. We don't want our aid to be diverted or misused or manipulated by armed groups, period. And we go into conflict zones with that idea in mind, and we devise an approach accordingly. So if you want to meet on some kind of middle ground, that's the place to meet. But trust us, have confidence in us. I mean, we've actually, the irony of this, again, there are just so many contradictions, but one of the ironies is that for our own funding in our own sector, we can get a Treasury Department license that allows us to use our own procedures in our own discretion to make sure that aid is not misused. That's all we want. So, I mean, we've got one part of the government that is basically we're fine with and can operate under those procedures, and we've got another part of the government that's trying to put this far-reaching, draconian set of principles in place. Now, of course, I hesitate to even point this out, because if there's any reconciliation of the contradiction, I guarantee you it's going to be in the wrong direction. So, you know, our OFAC licenses will all be revoked, you know, within 72 hours if word of this gets out. But again, it's just such a muddle. It's such a confused picture. And, you know, we have, again, no problem with meeting on a middle ground around no diversion and no misuse.
Just very briefly, I would say all the arguments that are raised in defense of the current counterterrorism regime, at least as it applies to civil society, the one we hear the most is about fungibility. And there's a congressional finding when the material support laws passed that every dollar given for charitable purposes or to the social wing of a charitable foreign terrorist organization frees up another dollar to be used for explosives. Now that is a danger that the sector has been very well aware of and has all kinds of procedures and resources in place for organizations to use to avoid that happening. There's never been any example of it happening brought up to justify this congressional finding. There were hearings where witnesses appeared and brought forth no examples. So it's, in a way, it's kind of addressing what appears to be a non-problem with a sanctions regime that lacks any proportionality. And I think it's that kind of flexibility and proportionality that we're looking for, and that this is not an either or choice, that the interests are really compatible. It's how we choose to make them operational that matters.
Thanks.
I think y'all covered it, but I would just add that there's, I think, often a failure to understand the sophistication of many of these groups that do understand the nuances and the gray groups, the gray areas, and that I think the NGOs and the individuals involved that I've seen get it, understand it, and also strongly oppose terrorism. That's why they're trying to shift these groups into the peace process. So I just think it's important for those looking at this issue to recognize the sophistication in many of these groups. They're not wild-eyed lefties trying to do peace, love, and justice, but I think a lot of the criticism doesn't really look at how careful they are. And so I commend them. I think they've got it just about right.
Great, thanks very much.